I'm coming at y'all. I meant to come earlier, but unfortunately, I've been having some problems with my internet. Hopefully, the internet will stay up. I want. There's been a lot of stuff. Like what I like to call the fallout from the Karen Reed case. And with that being said, we're gonna take some time to go over it. Let's go.
Home Emporium is an exceptional shopping experience offering unique home furnishings and distinctive build.
Even mammoth-inspired food. And why Erie?
I mean, it seemed like their application was really fun.
Buzz is only expected to appear in a handful of games. Oliver says what happens next depends on the team and the fans.
Good night.
More Americans turn to NBC News than any other news organization.
The Karen Reed trial continues to make headlines a month later.
What's changed since the verdict, and could fallout from her trial have an impact on other trials coming up in Massachusetts?
We're covering it all on Canton Confidential tonight at 7 on NBC 10 Boston.
The Chevy Equinox is more than an SUV. It's your chance to give back. And your safety check.
Whoa.
All at an incredible value. It's more than an SUV. It's your Equinox.
Qualified lessees can get this 2025 Equinox LT for around $319 a month. Visit your New England Chevy dealers. You're watching NBC 10 Boston. News worthy of you. The Karen Reed murder trial, 1 month later. Tonight, we look back at how we got here, what's next, and the fallout from this high-profile case.
If I was district attorney, would have said more and would have said things different.
We're covering it all with our panel of experts. A special edition of Canton Confidential, the Karen Reed murder trial, starts right now.
Weeks have passed since the conclusion of Karen Reed's second murder trial, a case that not only captivated New England, but the nation as well. Good evening, everyone. I'm JC Monahan.
And I'm Glenn Jones. First up, we're looking back at the trial. For that, we turn to our Melody Mendez.
First, the prosecution. The man at the helm, Special Prosecutor Hank Brennan, a lifelong attorney with an impressive resume. Brennan was hired by the Norfolk County DA's office in September of 2024.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
And from day one of Karen Reed's trial, it was clear Brennan was taking a different approach than his predecessor. He built the Commonwealth's case on Reed's own words.
You'll hear her words.
While Brennan spent less time defending his witnesses from defense accusations, and there were fewer personalities than the first trial, there were a number of aha moments.
You knew that Google search for Hossalong to die in cold points a very uncomfortable finger right toward you, correct?
I never did that search at 227.
In trial one, the internet search Hossalong to die in the cold garnered a lot of attention. During this trial, Brennan quickly discounted the search with expert analysis.
As long as Safari doesn't close, then the timestamp will remain the same.
Then, when the state's expert witness, Dr. Judson Welcher, took the stand, the so-called blue paint test seemed to resonate. The accident reconstructionist using blue paint on a similar SUV and his own body to try to show John O'Keefe's injuries were consistent with being hit by Reed's Lexus. But the test was later called into question by a defense expert from accident reconstruction for ARCA.
You can't say with any scientific certainty that that area of paint corresponds to where the abrasions are.
38 witnesses were called in 31 days across testimony spanning more than 7 weeks. Notably not on the witness list, former Mass State Trooper Michael Proctor. For the defense, Trial 2 saw the return of attorneys Alan Jackson, David Yannetti, and Elizabeth Little, plus a new face behind the bar, Robert Alessi, and a surprise, a juror from the first trial, attorney Victoria George. The expanded team took lessons from Trial 1 to evolve their strategy for Trial 2.
A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. His name is Michael Proctor.
The defense took the opportunity to shine a light on what they called faulty police work. The defense questioned the use of red Solo cups and grocery bags
Yeah, now
to
that
collect
was
blood
stupid.
samples. How Reed's SUV appeared to have additional damage after being taken for police inspection.
That middle section was intact when I was there.
The decision for officers to remain outside the home where John O'Keefe's body was found in the yard.
I would have to twist circumstances to have the right to search Brian Albert's house. We had no reason, and there's been no reason since.
How about this? There's the dead guy on the lawn. It looked like he potentially could have been a physical altercation. How about that?
And the decision to not pursue any additional suspects.
You learn that in Michael Proctor's world, he didn't care about finding the truth. In his world, his priority was to protect the Brotherhood, to protect that blue wall, to protect his friends who were at the Alberts' house that night.
At almost every turn, the defense conjuring former trooper Michael Proctor's name.
Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He was fired.
No matter what size your shop, a flash dryer is a very important piece of screen printing equipment. Curing with a flash dryer.
Insulting Karen Reed. He dehumanized this woman. He was fired for this blatant bias.
But perhaps the most highly contested testimony in the case came from the defense's witnesses from ARCA, a forensic and engineering firm. Dr. Daniel Wolf and Dr. Andrew Rentschler testified John O'Keefe was not hit by a vehicle, saying neither the injuries to his body nor the damage to the SUV would match that possibility.
In any of the testing that you did you ever see taillight pieces cut, puncture, or fray the sleeve of that hoodie?
No. If you can't prove that the impact happened, then everything after that doesn't actually matter, does it?
Summing up the defense's approach from their opening statements and beyond, there was no collision.
None of us know what happened to him. What do we know is that wasn't Karen Reed responsible for his death? She did not kill him.
Karen Reed is innocent, and she didn't do this crime.
That was reaction from two jurors just days after the trial ended. One of them was the jury foreman he spoke with the Today Show. And look at that soul around the table once again. Our chief legal analyst, Michael Coyne, and our courtroom insider, Sue O'Connell. All right, Michael, you just heard from the jurors there. They did not believe that Karen Reed was responsible for John O'Keefe's death. And when you look back on this case, do you have any reason to second guess the way Hank Brennan presented the evidence? Or was this more about bad policing that there was just no way he could overcome?
Yeah, I think now when we really start to revisit it, I don't think he could have tried a different case. If you remember, the first case was very different. It still was a hung jury. He tried a very different case. The fact is, it was always going to be virtually impossible to overcome the horrible, unprofessional police work at the outset, the collection, the preservation of evidence, and I think in many ways to overcome what some folks on that jury likely thought at the outset is that, let's see if the government can prove it, but they've got a heavy burden to overcome with respect to the problems that were self-inflicted here.
Well, it's been a month, and we've heard not just from some of the jurors. We also spoke with two members of her defense team, and they shared a number of opinions on the case, including the view that their client was overcharged.
She was overcharged twice. He had told the case to the grand jury, and it wasn't enough to, in my view, overcharge her with manslaughter. They had overcharged her with second-degree murder, which I just thought was crazy. I think the case was treated differently because of who the victim was.
That was part of our conversation earlier this month with defense attorneys David Yannetti, who represented Reed in both trials, and Robert Leslie, who joined in the second trial. And Sue, I know you've spoken to several people who think she was overcharged, and they think even more specifically than that, it is because the victim was a police officer.
Yeah, absolutely. I mean, it's every single person I spoke to said when you have a dead police officer who may have been assaulted or murdered, you definitely need to get in there and make sure you're charging, because, you know, those crimes are heavier than crimes against just regular civilians for many reasons. Of course, that also begs the question that if she was overcharged because he was a police officer. Why didn't they do a better job investigating? Because he was a police officer. And that's what I talked to a couple of jurors about, the struggle they had, where I think one of them said to me, I understand the charge, I just don't understand the lack of follow-up to that charge.
All right, as of today, we know, if we go through all the players here, Yannetti is practicing in Boston, Alessi is back in New York, and then there's Alan Jackson. He has signed a movie and a book deal about the case, but otherwise, he hasn't said much to the media. However, he did put out a statement not long after the verdict was reached. It took aim at prosecutor Hank Brennan and said in part, quote, the jury has spoken, but Special Prosecutor Hank Brennan is in an egregious breach of prosecutorial ethics, has tried to publicly
They need to get that judge
the
too.
Commonwealth fell wildly short of that responsibility.
Very
And
much
here's part of
short.
what he was responding to. This is a snippet of the statement Brennan released. I am disappointed in the verdict and the fact that we could not achieve justice for John O'Keefe and his family. Neither the closed federal investigation nor my independent review led me to identify any other possible suspect or person responsible for the death of John O'Keefe. In the wake of this trial, Special Prosecutor Hank Brennan racked up quite the bill.
And we're talking more than $500,000. That's how much taxpayers in Norfolk County paid for his work. Here's a breakdown of Brennan's pay, which did include charges for work done pre-trial. If you do the math, the final tally is around $566,000.
So, Michael, you've defended in the past the need to spend what is necessary in the pursuit of justice, so we get that. But it's also a political decision because this is a political office. Did what happened in the retrial mean that future DAs will be hesitant to bring on a special prosecutor even when you think it's warranted?
I think that there's little doubt of that, Glenn, because if you think about it, why wouldn't you, if you were a new DA and creating a better office, why wouldn't you hire more highly seasoned trial lawyers and pay them at $566,000? That's going to get you 2 public servants at the minimum who are highly skilled, trained trial lawyers who would likely have been able to try this case, and you would have them for the whole year. So I do think the economics will come into play. But I also think we've got to be very, very careful in allowing defendants who have a lot of assets and a lot of power and a lot of play be able to buy their way out of the system. And that's in essence why they needed to bring in new staff here to really try to right the ship, because the ship was a mess when Hank Brennan was hired.
And on that note, let's talk about the fallout that has happened since this trial, especially in law enforcement. Since the second trial ended, Sergeant Yuri Buchanan and Trooper David DeChico have been transferred out of the DA's office. Michael Proctor was fired weeks before the second trial, in part because of his behavior during the Reed investigation, although they said it was about lack of ability in his position. He's trying to get his job back. Detective Lieutenant Brian Tully was transferred out last year. Following the verdict, State Police Colonel Jeffrey Noble released a statement saying, quote, the events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability. Our focus remains on delivering excellent police services that reflect the value of professionalism and maintain public trust.
So Colonel Noble, who you heard from there, obviously has a lot of work to do, Sue, and I suppose we should point out he was hired from outside the agency, which is rare, maybe even an advantage in this situation. Can he restore public confidence? And if you think he can, how long will it take?
Well, I think he can, because again, the overwhelming number of state troopers are doing their job.
A12 makes going back to school easy. We deliver an education that takes your child beyond the classroom.
State troopers are doing their job. Every single day they get up on the stand, they testify, they don't make news, there are convictions, they do what they're supposed to do. And then you have a handful here that have really disgraced the state troopers.
How did they all end up in this case?
Well, that would be maybe because they were all in District Attorney Morrissey's office. That might be an issue. I don't know about that. But yes, he can right the ship. But we do have problems with the way the state police are organized in that they don't have an outside agency who who polices them, as we have done in our Commonwealth Confidential show, seeing that other states do that. So that is a roadblock he has, but yes, he definitely can restore the trust that he can.
And then let's talk about how many cases Michael Proctor has had his hands in. Number of murder cases before he was filed, and now those investigations are being looked at more closely. We're talking about the Brian Walsh case, the Sandra Birchmore case, the Miles King case, and today the lead prosecutor in the first Karen Reed trial, Adam Lally, testified about how Proctor handled evidence that was supposed to be shared with the Miles King defense team. It was very weird to see Lally on the stand in the same courtroom where all of this went down.
Yeah, it was a wow moment. So, Sue, a lot of people are following the cases that JC just mentioned because they followed the Karen Reed trials. What's the net result of that, do you think?
The net result of folks following
The extra spotlight.
Well, I mean, I hope that reform happens. I hope that some of the things that we see, that if they are repeating in these other cases that are mismanagement or bad investigation, whatever the cause is, if we see evidence of that, I hope that people take action and there's reform for it.
Well, what could the
Let
implications
me
be,
let me
though,
go
in
let me
the,
go
like,
back
the
a
Walsh
little
and
bit.
the Birchmore case?
Well, if the level of distrust of law enforcement is so extensive as I'm afraid at times now it is, I think it goes well beyond state police. If you think about the attacks on the FBI and all of the rest of the attacks on law enforcement and some of the misdeeds, it's going to take a long while to build that trust back up, a long time, and a lot of reforms. And the problem is the Birchmore case and the Walsh case are going to have to be tried well before those reforms are even discussed in serious detail. It's going to be make success for the Commonwealth
Very
in those
much.
two cases more difficult because the jury comes in
Because
on
Michael
some
Proctor
level of
fucked up so
distrust
badly.
now with the prosecution.
Michael, Sue, thank you very much. Like riding a bike. We're going to have a lot more coming up. Our conversation continues right after this short break.
Up next, we're looking ahead at the civil suit filed against Karen Reed.
Plus, the County District Attorney. Funds raised for incumbent Michael Morrissey could be meant for something else. We'll be right back.
We understand selling your family home is a big deal. Home investors that we buy
I'm gonna rewind this back a
We can
second.
meet you in person and even give you
Before he was filed, and now those investigations are being looked at more closely. We're talking about the Brian Walsh case,
Brian
the Sandra
Walsh,
Birchmore case,
Sandra
the Miles
Birchmore,
King case,
and Miles
today-
King. Let me write these names down real quickly. Give me a second. Brian Walsh. Miles King. And Central Birchmore. Birchmore. Alright, I got those names. And that's the main reason I wanted to come back to Michael Proctor, because I knew that there were other cases that he was on. So not only do we have to talk about the Karen Reed stuff, we also have to talk about what did Michael Proctor do on these other three cases. With that being said, let's get back into this.
The lead prosecutor in the first Karen Reed trial, Adam Lally, testified about how Proctor handled evidence that was supposed to be shared with the Miles King defense team. It was very weird to see Lally on the stand in the same courtroom where all of this went down.
Yeah, it was a
1 second. Okay, we back.
wow moment. So, Sue, a lot of
people are following the cases that JC just mentioned because they followed the Karen Reed trials. What's the net result of that, do you think?
The net result of folks following
After
it?
spotlight.
Well, I mean, I hope that reform happens. I hope that some of the things that we see, that if they are repeating in these other cases that are mismanagement or bad investigation, whatever the cause is, if we see evidence of that, I hope that people take action and there's reform for it.
Well, what could the implications be, though, in the Walsh and the Birchmore case?
Well, if the level of distrust of law enforcement is so extensive as I'm afraid at times now it is, I think it goes well beyond state police. If you think about the attacks on the FBI and all of the rest of the attacks on law enforcement and some of the misdeeds, it's going to take a long while to build that trust back up, a long time, and a lot of reforms. And the problem is the Birchmore case and the Walsh case are going to have to be tried well before those reforms are even discussed in serious detail. It's going to be make success for the Commonwealth in those two cases more difficult because the jury comes in with some level of distrust now with the prosecution.
Michael, Sue, thank you very much. Like riding a bike. We're going to have a lot more coming up. Our conversation continues right after this short break.
Up next, we're looking ahead at the civil suit filed against Karen Reed.
Plus the upcoming election for Norfolk County District Attorney. How funds raised for incumbent Michael Morrissey could be...
Guess which student has a better chance of getting into an Ivy League school? First, take a look at Zach. He's valedictorian, national merit.
Michael Morrissey could be meant for something else. We'll be back.
We understand selling your family home is a big deal. Home investors, the We Buy Ugly Houses people,
For you, to make your purchase even easier, along with 0% financing, we also offer free delivery, setup, and free removal of your old mattress. You'll find a better night's sleep this summer on a new Tempur-Pedic or Stearns & Foster mattress from Fernie and Phil's.
First Karen Reed trial. And then after, Morrissey got out very quickly after that first trial to say he would try the case again. The second trial happens, and basically haven't heard.
Hardly a peep. Morrissey has been the DA for more than a decade, winning by wide margins. But as our Matt Pritchard reports, candidates are lining up to challenge him. Michael Morrissey is tough to track down these days, staying away from cameras in the wake of the Karen Reed verdict, even as contenders begin to stack up for the 2026 election. The war outside the Denver courthouse, echoing through the 2026. Karen Reed found not guilty of every major charge in the death of her boyfriend, Boston police officer John O'Keefe, capping off years of state prosecution efforts and hundreds of thousands of taxpayer dollars.
Proof beyond reasonable doubt, such a high standard. Let's acknowledge failure here and figure out how we're going to move forward.
The verdict shows, was a highlight of all the mistakes that were made in that case.
The high-profile case leading to fierce criticism of District Attorney Michael Morrissey, with challengers quickly filing their paperwork, including Democrats Craig McClellan, Juna Perkins, and Jim Bearcat. Let's start with McClellan, a former assistant DA in Suffolk County.
I am going to bring us back to the basics here, and that is, remember that holding a public office is a service to the public.
Juna Perkins also served as an assistant DA in Suffolk.
I've been a lawyer in Massachusetts for 32 years, and I've spent that entire time helping hundreds of families.
Jim Bearcat comes with a somewhat different resume, highlighting 10 years as a public defense attorney.
My background is being on the other end of prosecution.
But they won't be the last to enter this race. More Dems could emerge, and Republicans as well.
Or we might end up with one of these candidates, but either way, we're going to be in good shape.
The big question, will Michael Morrissey run for re-election? He's been in the job since 2010 and has run unopposed in each of the past 3 elections, including primaries. Efforts to ask him about his plans went unanswered, both via phone and email. Plus, he appeared to drive past us at his office and head straight into the building before answering questions.
It is a little underwhelming that we haven't heard more from him. I understand the position that he's in. He's in a really tough spot.
Now, whatever he chooses to do, one thing is clear. 2026 will bring a competitive contest to Norfolk County.
His silence in the wake of these decisions is cowardly.
Whoever's incoming has an uphill battle.
We have a fairly disconnected, inaccessible,
invisible elected leader in that office.
And we gave District Attorney Morrissey multiple opportunities to take part in this story on Thursday and Friday of last week and spent much of the day today outside of his office. We did not hear from him either virtually or in person. In Canton, Matt Pritchard, NBC 10 Boston. District Attorney Michael Morrissey has a major fundraising lead over the other candidates looking to take his seat. And major is an understatement. He's got more than $425,000 cash on hand. His closest competitor, Juna Perkins, is far behind at $39,000. Craig McLennan has raised $18,500, while Jim Barakat's campaign has just $84 on hand.
Damn, really?
Let's bring back Michael and Sue. Sue, to you. If Morrissey ran, could he win? And if he doesn't win, where does that almost $500,000 go?
Yeah, no, I don't think he can win. And I think he knows that. That's why he's not saying anything. And I think there's a lot of money nationwide that's going to pour into these other candidates and candidates yet to be announced, even on the Republican
Yeah, $84, you're not really competing.
Right, not yet. But the money can go to a number of places. He can keep it in his campaign. It's a campaign. He can return it to the people who sent it to him. That never, ever happens.
Seems unlikely.
Be fair and clear. He can use it to endorse and give to another candidate. He can use it maybe as power to maybe say he's going to do that, but not. And remember, if he's in a situation where he needs to defend himself in a civil suit or a criminal suit, he can't use that money for that purposes, but having that money certainly is a comfort in many ways. Again, it's not his money, it's the campaign's money, but it's his power.
Up next for Karen Reed is civil court. She's facing a wrongful death lawsuit from John O'Keefe's family. The family alleges her actions led to O'Keefe's death. The family is suing Reed as well as the two Canton bars the couple visited in the hours before his death. Reed recently moved to dismiss the case. She also added 3 new attorneys to her civil defense team. The total is now 6. Her next hearing is set for September 22nd. So, Michael, of course, the standard of proof is lower in a civil case. So, given that, does the O'Keefe family have a shot here?
Hey, have you ever been told you have a nice voice? Well, what if I told you you could turn your voice into actual money? Sound too good to be true? Well, come closer. I'm about to show you how to turn your family have a shot here.
Very much so. And it's not as complicated as even having to say that the vehicle hit him, which they were unable to prove in the first case. But the bars, did they overserve the defendant Reed as well as John O'Keefe? Could that have contributed to his death? And that's on the tavern's liability. And then you could even make the argument, it will be a harder argument to make, but even if she didn't hit him, did they have a special relationship? Usually that's mother and child or parent to child, but did they have a special relationship where she owed him a duty to take care of him and not leave him in a blizzard in a lightweight coat where he had consumed so much alcohol? Some liability for her not having taken better care of them. I think that's a difficult burden. They're still likely going to have to do what they were unable to do in the criminal case, is connect the vehicle striking him in some way to his ultimate death.
Michael Coyne, Sue O'Connell, as always, thank you for being back at the table to discuss the case. 1 month later, you have been watching a special edition of Canton Confidential, the Karen Reed murder trial. Have a great night.
Watch Priscilla Casper and Colton Bradford, weeknights at 6 on NBC 10 Boston.
Tax-free weekend can get a little crazy, so avoid the crowds and save even more right now with 15% off everything and get up to 60 months no interest. Experience the difference at Jordan's.
You bought your Toyota because Toyota is the longest-lasting brand. You put your trust in Toyota's reputation for quality. Now put your trust in Toyota-trained certified technicians who install genuine Toyota parts to help keep your Toyota a Toyota. Get your Toyota ready for that adventure-filled summer road trip. See your New England Toyota dealer for affordable service offers. Trust the experts at Toyota Service Centers and keep your Toyota a Toyota.
Severe weather can strike anywhere at a moment's notice. Whether you live live in Drake,
In Webster.
in Worcester,
In Shirley.
or in Quincy, wherever you're watching from. NBC 10 Boston's First Alert Weather Team is working hard to keep you safe with the most accurate forecast around.
No other weather team in Boston can say that.
Because the most important thing on our radar is you.
Is you.
Is you.
Is you.
Because the most important thing on our radar is you. First Alert Weather on NBC 10 Boston. Weather coverage worthy of you.
Okay, I think that's it.
Sullivan, who represents the Norfolk County District Attorney's Office. I had a conversation with the Assistant U.S. Attorney Wallachia.
This is more Michael Proctor.
Whether or not it's been communicated to the U.S. Attorney's Office and or the federal judge.
And I pray and hope that y'all can hear it loud and clear.
Judge Frenier and everybody else are looking for this February 2024 order. When I had that conversation with Assistant United States Attorney Wallachia, he didn't indicate that there was a conversation one way or the other. What he said to me is he needed to speak to Mr. Sullivan, and then he would get back to me. When I called again, I didn't get something affirmative in terms of is that being discussed amongst the things that need to get resolved. Because this court has made it clear that you're not inclined to make a decision on my request of discovery until we get that order. And I just want to make sure we're not waiting until next week, and then all of a sudden someone says, now we need the order. So to the extent that...
Look, I would like to see the February. But I also have to deal with the issue of whether, regardless of what the order says, whether there's still a constitutional obligation on the DA's office to review the information that they are in possession of to determine whether it contains exculpatory information that should be produced in other cases. I appreciate the fact that somebody says you can't look at this or you can only look at it for a limited purpose, but I'm not sure that trumps the constitutional obligation that the DA's office has to review stuff. I'm trying to avoid having to decide that if we can get the authorization from the federal court so that we don't have conflicting orders, but we're not there quite yet. We need to run it to ground a little bit more, and hopefully we can get some movement this afternoon. I think I told everybody last time, out through the 11th, so I'm back the 12th. I'll see you the 12th. I'll see you the 13th. Whatever is convenient for everybody to get back together. I think...
Judge, I appreciate that 100%. My concern is, if we know that we're running up against that clock that runs out on the 18th of August, is there a way that the government can now, or the Commonwealth can now ask the government to extend that order again? I don't want to be in a situation where you finally make a decision. I think the
Commonwealth understands that.
Yes.
And I invited you the last time to seek to intervene or to do whatever you needed to do to communicate your concerns to the feds.
I understand that, and that's what I did, Judge. I had a conversation with the U.S. Attorney's Office, had a conversation with their attorney, and the plan was, if we did not hear back in a way that was reasonable to us, both myself and Attorney Sullivan planned to file a motion on Wednesday to intervene.
Okay, great.
That was what we were planning on doing. So that's before we knew that they weren't going to have a meeting until 4 o'clock on Tuesday, Judge.
Yeah. All right. So do you want to set a date? You want to say the 12th?
I think the 12th at 2 o'clock, just from my reading of the emails that was going around yesterday, seemed to be the best.
I think that's what Ms. Irwin said.
Yes.
Okay. So we'll put, let me just see, we will put...
Except for Mr. Wester, I do want to say, who will still be on vacation.
Right. We will put King, De Los Santos, Johnson, and Chanchillo, and I think also Walsh.
Yes, please.
On for 2 o'clock on the 12th. On the issue related...
They're supposed to be getting to Proctor in a minute. I just don't know when.
Is there any way to get an update from the 4 o'clock meeting today, Judge, so that we're not waiting until the 11th or the 12th, the morning of the 12th, to find out what happened?
I'm sure that the Commonwealth will alert folks to whether progress is be on the same page ultimately for the hearing on the 12th, and you're going to have to act quickly. The Commonwealth may have to act very quickly depending on what happens.
And I've been doing that.
Yeah. Okay. Thank you.
Thank you.
Thank you.
All right. Now, with respect to the King matter, we're just dealing with the issue of the late disclosure, and Sure. The close of last
I'll be
hearing
back in a
was
second, y'all.
to provide the court with which documents were either exculpatory or would inhibit the defendant's right to a fair trial, be prejudicial to him. I have not heard of one document since these have been provided in April and May. And to that end, I've asked the court to order that right now. I think that this has gone on, this is not the second day of the hearing, and the Commonwealth is unaware of which document or which documents are prejudicial to the defendant and prevent him from having a fair trial.
We had two things I was looking for. I was looking for that, and I was also looking for some sort of a agreement of the parties, if it was worked out, to identify which of the documents were newly disclosed, which were partially disclosed previously and fully disclosed more recently, and then there was the prejudice analysis as to the new documents. So there was sort of a two-phase process. I don't know whether either one of those phases happened, whether the parties met and tried to work out an agreed list as to what was new or what was not new.
I endeavored to work with ADA Hickman to ensure Your Honor had a complete list as diligently as best as we could of what documents were previously produced, and that was provided to Your Honor. I believe it was sitting on your desk Monday morning. It was the third exhibit that the Commonwealth provided. We did confer on Friday afternoon. It was represented to me that counsel would be providing us a disagreed list or a number of other lists to show the court what they disagreed with.
I got a file of documents.
And we got that as well.
This is the file that I got, I think, from the Secretary's office. I don't know if in there is the chart that you folks worked out, you say was on my desk. I'm not sure I know what you're referring to in terms of a list that was new or not new, but maybe it's
a table. It's the third. If you look in the middle folder, it's underneath that. There, in a rubber band, it's in your hand.
Oh, here. Okay. This one.
Yes. Third document.
Okay, I gotta show you this. It looks like a regular laptop stand right, but wait for it, this thing is actually a 7-in-1 docking station. Like it's got HDMI, USB-C, USB-A, SDTF all built in once you plug it into your laptop boom. You can hook up a hard drive, SD card, even a second screen, and you can adjust it to multiple angles. Perfect for working or watching stuff. It's super lightweight and folds up small, so I throw it in my bag for work or travel. For the price, it's honestly a steal. If you've got a USB-C laptop, you need this, click the link. Seriously, don't sleep on this one.
As an owner of Walton Goggins goggle glasses, I know how to make slick-looking goggle/glasses. But I have no idea how to make slick social media-style stuff to sell it. But GoDaddy Hero uses AI not only to create social content out of thin air, it can build a whole social media calendar just for my business. So all I had to do was upload a video of me and my pretty face, and voila. Walton Goggins goggle glasses are great gifts for all guys and gals. Try saying that 10 times fast. Look like you know what you're doing at GoDaddy.com.
That is what I prepared with the assistance of ADA Hickman. Okay. Which specifically describes what, if anything, is minorly different. That was provided to counsel on Thursday last week. We met at a teleconference on Friday. Counsel was working on their own lists. Okay. So to answer your question, no, there was no agreement as of now. We endeavored to meet earlier and understand from my pleading what counsel disagreed with, but that was not reached. Provided you, the Commonwealth has provided you as best we can what has been previously provided. Okay. If there's any subtle differences, we can supplement that at a later date, but at this point, I know ADA Hickman has worked very hard to go through the materials.
Thank you, Doctor. So we provided 3 charts, both to the Commonwealth and to the court. The first chart deals with the information contained in the Commonwealth opposition, the disputed document, of the motion to dismiss. The second chart deals with all of the new discovery, which I thought we were in agreement that the second chart is everything that was new, it hasn't been disputed by the Commonwealth. And the third chart is the information.
So you have two dueling charts, huh? You have the Commonwealth's chart and your chart.
Yes.
That's exactly what I did. Why didn't you get together and work? Well, I mean, figure out a...
I tried here.
Well, I think we both tried. I'm playing catch up here, Judge. They've had this information since 2021. I'm trying to go through it, organize it, and figure out where it fits in the most timely fashion that I can. And that's what I'll spend my time doing. So when we spoke on Friday...
Do I have a list of the items which are new or which you claim to be new, and that I can then cross-reference against the Commonwealth list, which you say are
Okay, I'm back.
prejudicial, are exculpatory, and you're behind the eight ball because of late disclosure, notwithstanding.
I hope they ain't mention Michael Proctor.
Where will I find that?
Where we find what, Judge?
Your list of the explanation of why particular things are prejudicial to you.
And this guy here sounds almost dumb as bad.
List to them literally Monday morning saying, based on everything that you provided since April, here's what I think is new, and we all agree it's new. That's chart number 2. Here are my disputes from what you say you already gave us from the first part of your motion, and here's what we say is new from the second part of your motion. That's what I was able to accomplish in the week that we had between now and the last hearing.
All right, so you need more time to get the other stuff.
I do.
Okay. How much time do you need?
It depends. I just got more discovery this morning, Judge, so it just keeps happening. So in order for me to get my hands around it, they have to be able to certify that I have everything, Judge. So I can't keep doing this piecemeal the way that they've asked me to do it over the last month and a half. So do we have everything? Because if we do, I'm happy to sit down and say this is where we are and this is where we stand. But if we don't have everything, then we're going to come back in a week and they're going to hand me something else in the morning of the hearing and say this is now
as an initial crack, I wanted a list of what was new and what was prejudicial in the two notices as of when the motion to dismiss was filed.
Yes,
that's what I think we were shooting for. We understood that some new stuff had been produced after that.
Yes.
And I don't know what the explanation is for that, but in any event, we're looking at what was filed as of the time the motion to, what was new as of the time the motion to dismiss was filed.
So, Judge, what I did with the new information is I put it in chart 2 as a description of it. I cross-referenced it to a BCF number if we had it, and I put it in a discovery category, which is I thought what the court asked me to do. So some of it has to do with jail calls, some of it has to do with social media, some of it has to do with search warrants. I categorized it in a way that I think that I was hoping it would help the court understand.
Can we make a record here?
Yes.
You were referring to lots of stuff which is not in the record, right? We admitted in the last hearing exactly one document.
Yes.
Right? If you are referring to particular charts, let's be clear about what they are. Let's mark them as an exhibit, and then we'll discuss what we need to do. You can explain what those documents are to me without a witness. I think that's sufficient, and then we'll decide whether we're going to proceed with the hearing on an evidentiary basis today or not.
Thank you.
All right. So I've been handed 3 charts. Chart 1, chart 2, and chart 3.
Hopefully all y'all can hear this.
Okay, any objection, at least for the record here? No objection. Okay, so these will be marked as, unfortunately, exhibits 2, 3, and 4, because we already have an exhibit 1.
No, you're on.
Look like the judges started reading the documents. That's why it's silent. I know some of this stuff is boring, but in order to understand what we need to understand, we gotta go through everything.
All right, how do I deal with these charts? How do I read them? They look like you're talking past each other to some extent. That they're not. That they're. So if I look on Exhibit 2, which is the defense chart number 1, discovery address in Commonwealth opposition to our motion to dismiss. Item 1, copy of search warrant affidavit for T-Mobile cell phone. Draft affidavit. What does this tell me?
So what that's meant to tell you, Judge, is that the Commonwealth and their pleadings are indicating we actually got the search warrants. We didn't get the search warrants.
No, hold on. Not argument, just what does it show? Document description is received by King.
Right.
What is that? What's in that column?
So that column is what we actually received as opposed to what the Commonwealth is claiming they gave us. And it's categorized.
Oh, that sounds like withholding evidence. You asked me.
So for the first two, Judge, if I could just show you. For the first two, the Commonwealth is claiming that they already provided those search warrants to us. They haven't provided the search warrants to us, Judge. In fact, what they provided to us was...
No. Just slow down. I want to understand what Exhibit 2 shows.
So Exhibit 2 takes the Commonwealth's opposition.
What's in column 1?
Column 1 is the description that was received by us.
You're quoting something from what?
Discovery notices, Judge.
Draft affidavit for search warrant 21 SW.
Yeah, at least it's got more knowledge than Bev, but not by much.
That's what the Commonwealth made these documents. To try to convince the court that we already had them.
Okay, and you don't have any Bates numbers here, so I can't go and find these things, right?
Right, because the Commonwealth didn't have the Bates stamps and the ones that we did. So if you look down to the second column, we do have Bates stamps. There were some things that we did.
Second column?
Second part of the chart. We were able to provide Bates
Like the
stamps.
chart?
No, just where it says notice 4925.
All right, so how do I compare what you have to what the Commonwealth has provided me? I need you to be on the same page. I need you to go through every single document.
This dude don't get it. She's trying to tell you that evidence is being withheld, idiot.
Listen, son, every single one. You have to address every single one, okay? And you have to make a chart saying this was produced in Discovery Packet 1. This was never produced before, okay? I don't need an argument associated with it. I just need to know the universe of the problem. I need to get my arms around the scope of the problem. And then I need to know, with respect to anything that's new or substantially new or partially new, why you're prejudiced by the late disclosure of that additional information.
Understood.
So I don't have that here, right?
I thought you did. I understand now you don't follow it the way that I followed it.
Well, I don't understand it, so I need you to explain to me why you think I do have that, if I do.
Well, I think you have part of it, Judge. I don't think you have all of it.
All right, so I need all of it.
Okay.
Okay, so I understand the scope of the problem, and then I can analyze the question of prejudice. After you've analyzed the question of prejudice.
Yes, Judge.
So how are we going to do this?
We're here at 9:24, and we happen to be with parties downstairs for the next 3 hours.
I think it would be a much more productive use of time than
Oh, I didn't mean to blow my table.
or anybody else. Because there are real constraints on the courts
provide a remedy beyond the remedy that has already been provided, absent real showing of meaningful prejudice. And so I need to understand where that prejudice is coming from. And it's, so, you're welcome to spend the next 3 hours doing that.
Sure, Your Honor.
Okay. I know everybody's here. I know we have witnesses here. I'm sorry about that, but I think we need to do this in a logical order. I have a hearing at noon, from noon to 1, where I have to finish an evidentiary hearing in another.
Everyone out here with their little...
At noon, from noon to 1, where I have to finish an evidentiary hearing in another 2 co-defendant case. That'll take me from noon to 1 o'clock. I'm happy to see you at 2. If you're able to make substantive progress between now and then, or I'm happy to just see you on the 12th. But the 12th would not be for evidence, it would be for an explanation of the analysis that you've done on all the various documents that were apparently produced later.
I don't know where we'll get it. Maybe we could let the clerks know if we're
I'm happy to report back at 2, Judge, if that's what you want us to do.
I would like to release the witnesses.
Yeah, I think you should release the witnesses. I think and I think frankly I should see you on the 12th. Because if you're not done by 12 or whatever today, we're going to be together on the 12th. It's the soonest I can see you after today in any event. And it'll allow you to do the prejudice analysis, because that's the first part of it. That's great. Everybody's on the same page as to what's new. And then I need to hear from defense counsel, document by document, as to why it's prejudicial that this was lately disclosed.
Yes, Your Honor.
Your Honor, if I may, I believe we have one outstanding issue that was brought to the court's attention, and I believe Attorney Moynihan is here. We had the order of Judge Doolin of June 17th relative to Mr. Proctor's personal phone, and Attorney Moynihan has filed a motion on our last date relative to that order, and I wondered if we could address that today. It's the one outstanding issue that we have on Judge Doolin's June 17th ruling relative to Mr. Proctor's personal phone, Your Honor.
Judge, I didn't know we were addressing that today.
And my understanding on the last date, Your Honor, is we put it down for noon because Attorney Moynihan would be here, and then today would be the day that we'd be addressing this issue relative to Judge Doolin's order. I believe I asked the court on our last date whether or not this needed to go back to Judge Doolin, and Your Honor indicated that you would read the order and felt that you could make a decision.
Let's put it on the 12th, call your office. If for some reason you're unavailable, let me know. I'll get back to the bench. We'll set another time. It'll be 2 o'clock, yes. I have the papers here. I didn't read them for this hearing, but I will take a look at them now. So if you decide you want to be heard today, I'll hear you. Okay, all right. So if you can be available, we'll hear you on the 12th. Otherwise, let the clerk know and I'll hear you now. Okay? Okay. Anything else we can do today? Thank you.
Alright, that's it on that. Here's the final part.
Whoever invented this deserves a raise. Are you still putting furniture together with one of those Allen wrenches? Turning and turning, wasting time and breaking your wrist? Toss that junk out, but check this out. This is a 24-in-1 ratcheting screwdriver, the kind German engineers swear by. It's got 24 built-in.
I'm gonna fear they had just pulled the victim out of the water.
So circling over the school,
Dre is passionate about saving and helping people.
And when he said, if you get me on the ground, I'll do CPR on this guy, I had no choice. I had to find a way to get him on the ground. I'm putting the helicopter down in the field. This guy looks like he is not breathing, not moving. He's in cardiac arrest. Have a medic get here ASAP. Hey, 10-5 copy.
Officer Hoover spotted an opening, a field next to the nearby school where he could land. On the ground, watch Officer Smith sprint to the patient's side.
I knew right away, just looking at him, he was in bad shape and he needed compressions pretty quick, so I just did it.
Smith, who was a lifeguard growing up, was able to get the man breathing again.
It feels good. To me, it's just a regular day in office.
A heroic split-second decision and a life saved. Brianna Ross for NBC News, Baltimore.
For their help on that story, and we thank you for watching Nightly News tonight. I'm Tom Yamas. Tonight and always, we're here.
Tonight, the spotlight remains on the Norfolk County DA's office. The defense in a Milton murder case wants the files of Michael Proctor.
Proctor was back in court today, but did not testify as expected. Where this case goes from here at 7 on Commonwealth Confidential.
I love my family, but I chose a different path. I'm Josh Brown. My faith teaches that guys like me who are born lucky should help people who fall through the cracks. That's been my life's work. I'm running for mayor because Boston has become the most expensive city in America to raise a family. But Mayor Wu is spending over $100 million for billionaires instead of housing for the middle class. As mayor, I'll listen, not lecture.
You're watching NBC 10 Boston. News worthy of you. Tonight, the spotlight is on the Norfolk County DA's office. Cases under scrutiny after the firing of Michael Proctor.
I am defendant Mary's sister witness in a homicide claim.
Disgraced state trooper back in court, called to testify for an upcoming murder trial. But proceedings didn't go as planned.
I need you to be on the same page.
Courtroom discussion cut short over evidence.
I just got one more discovery this morning, Judge. They have to be able to certify that I have everything, Judge. So we can't keep doing this piecemeal.
The case heard today isn't the only one linked to Proctor. We take a closer look with our panel of experts. Commonwealth Confidential starts right now.
Karen Reed case may be closed, but the Norfolk County District...
Hello? Hello? Ah, shoot. My dang Wi-Fi. Hopefully it'll come back in, y'all. Bear with me. But like I said earlier, there's other cases that Michael Proctor has been the investigator on, and like the woman said earlier on her case, that she had issue with evidence missing, and the person who's the investigator on that case was indeed Michael Proctor. Now, if you're not familiar with Michael Proctor, I suggest y'all, go through my stuff on a Karen Reed case and or the Justice for Journal Keith clips. Hopefully I can get this Wi-Fi to come back in. Just trying. I don't know what's been the deal lately. Every time it rings, the Wi-Fi during the summertime, the Wi-Fi likes to act weird. I don't know why. I'm trying to give it another minute before it come back in. If it don't come in a minute, I'm just going to end this live stream and try to come back later. Because I'm scheduled for 2. Give it a minute. Okay, there we go. We back. We back in. Just gotta give it a minute. Dang, it came in and went right back out. I'm gonna give it a minute. See if it comes back in. If not, I'm just gonna have to end it. Come on. Come on. Come on. For the love of God, come on. Yo, I'm sorry. I'm just gonna have to end this one. I'm still gonna try to come back at 2. Peace. For the